Thanks, Kyle. Hi, everyone. I'm Dylan Clayton. I am the business section chair for the BCBA, which generally means I send you annoying emails and try to get you to do CLEs and post articles. Uh, when I recently did so, Mike was kind enough to propose a CLE, which I think is going to be a very interesting and broadly applicable CLE. And just a few notes beforehand. Mike is primarily focused or partially focused in the alcohol and business side of law. And he is barred in 5 states, which I think is actually kind of interesting. And he does his own wine bottling and wine. I don't even know the verb of that. Is that
winemaking?
Winemaking.
There we go. Yeah.
Yep. So this should be a really interesting CLE that is, going to tie not only into alcohol specifically, but businesses that have any relationship to alcohol. And one more note before I kind of take a back seat here. If you have any questions, Mike has said you can go ahead and jump in at any time, or if you have any general questions, you can wait till the end, whichever works for you, and I'll turn it over.
Thank you so much, and welcome everybody. I appreciate you making time for this today. As Dylan said, I practice here in Boulder, but I do practice nationally with liquor licensing and commercial litigation. But I do focus quite a bit on liquor licensing and liquor issues that come up in the business, in different business transaction, but just in the business world. So, you may have clients that touch different areas of liquor, heavily or lightly, but this course is intended to broadly view all of where I see the trigger points of the intersection of business and liquor law. So what I want to do is give you an overview of what liquor law really is in the first place, how we got here as a nation. I won't go too deep into it, but it is important to understand kind of the roots of where things are and what the tied house in 3-tier system actually is. That plays into most of the business transactions we'll talk about. And then a general framework and understanding of alcohol law here in Colorado, which is unique in a few respects, but every state has their own liquor laws. Again, then an overview of licensing. Then we'll walk through some entity selection and company agreement issues, leases, commercial contracts, mergers and acquisitions, and trademarks. There's a lot of stuff here, and on any particular point, we could do a few hours, but I want to give a broad overview and really just kind of get you thinking or perhaps pique some questions that we can discuss. Oh, and like they said, please ask questions. If you want to jump in the middle, that's great. If you want to wait till the end, also great. And again, you can always call me later or whatnot. So the modern system of alcohol is essentially just about 100 years old. And it started with the end of prohibition and the enactment of the 21st Amendment. The issue with prohibition was, well, there were many, but really the keys were alcohol became unregulated, but it became illegal, but people continued to make it. It was, of course, unregulated other than just being illegal. It became extremely unsafe. There were a lot of speakeasies and different types of, criminal activity, Al Capone-led crime waves that you might remember from the movies and those types of things. And just was a massive mess of liquor manufacture, distribution, and use. There was no safety involved. You might have heard the term bathtub gin. There were explosions. People would be dying. People would go blind. It was just this massive nightmare. And the biggest thing was there was a massive business, and there was no tax revenue for the United States or the states. So ultimately, that came to an end with the repeal of the 18th Amendment and the enactment of the 21st Amendment in 1933. The 21st Amendment gave the power to the states, each individual state, to regulate the importation and distribution of alcohol within each state. And so all of the states came up with their own plans. But in each state, you had what is called a 3-tier system. And that is, you have a tier 1 manufacturer, and that's what we call the manufacturer supply tier. That's tier 1. That's the introduction of alcohol essentially into existence. You also have in that the importer function, which also counts as a supplier. And that really matters when you're introducing alcohol into the country from some other country. And so we consider that to be, the creation of alcohol within the state. I'm sorry, within the country. So that's the supplier tier, tier 1. Tier 2 are the wholesalers. So all the manufacturers have to sell to a wholesaler, and then all of the wholesalers sell to the next tier, tier 3, which are the retailers. It seems. Hi, I think we have a question. Oh, maybe not. Okay. So those are the 3 tiers, and generally every state follows those three tiers. A lot of questions will get just kind of, theoretically, why do we have a 3-tier system? Why can't we just have an open and free market and everybody just sell however they want? I love the free market, but I certainly understand that over 100 years, having the 3-tier system ingrained in the system is probably not able to go away at this point. We're going to talk about some exceptions, but at this point, every state controls the manufacture, distribution, and sale of alcohol through the 3-tier system. And Colorado is no different, except we do have a little bit of a 4th tier for certain licenses, like importing. But that's probably too deep for today. So the keys for these tied house laws are to regulate the economic relationships among the tiers of the industry so that a manufacturer can't own a bunch of bars or a bunch of restaurants. If that were to be allowed, Budweiser would just simply own all the outlets, and you have what, again, is called a tied house. The retail arm is tied to the manufacturer, and that would have happened back in the 30s and 40s, and today we would have almost certainly have no independent retail actors. Everything would be controlled by a few manufacturers. That's the case in many other countries, and so that's a big reason as to why we don't do it here. And this is where, on the second bullet point here, again, the point, no individual entity may own and operate more than in one tier. That has really been blown up over the years, but in theory, it remains true. Generally now, it's considered that most states allow manufacturers and wholesalers to operate together if they want to, but never with a retailer. But again, some exceptions, and here we go, the Colorado exceptions. This is why I really do love practicing liquor law in Colorado. While a bit onerous in some respects, we have some great exceptions, and that really has come through the beer lobby over the past past many years. We have the ability for our manufacturers to self-distribute the products that they manufacture, and that's very important. They can only self-distribute the products that they manufacture, and then they can also sell DTC, which is short for direct to consumer. You can do that in a variety of ways through sales rooms or, online. You would sell, some of you may buy wine from wineries in Napa, for instance. That's what we call DTC, and they ship it into the state. Most states allow that. Colorado is also one. The other key here are a class of licenses for brew pubs, distillery pubs, and vintners restaurants. These are great. I love these licenses for my clients. Whenever they're thinking about brewing beer or distilling at this point, the distillery pub has been widely expanded in the last 2 years. Great option for any companies looking to distill spirits and also have a consumer-facing business. These allow not only the manufacture, but self-distribution and sale direct to consumer. So you get to participate in all 3 tiers. It's really a wonderful license and somewhat unique to Colorado, although a lot of states are following suit and allowing that as well. So that's the big exception, but generally you cannot participate in all tiers. Okay, the big question we get, and this is where, depending on your practice areas, I get a lot of calls and seeking help from other lawyers, do we actually need a liquor license for our client, or is what our client going to do require a liquor license? And these are really the questions that you have to go through. Are you going to be making alcohol? That's an immediate yes. Are you going to be blending any alcohol, what we call rectifying? Again, an immediate yes. Importing, selling, any of that. What I always get a question about, well, what if I'm not going to sell it? I'm just going to give it to consumers. I run a nail salon and I want to just be able to offer my clients a beer or a cocktail or something. Giving away alcohol is selling alcohol. You're not allowed to just give alcohol in a public setting. and have it be not a sale of alcohol. So any type of business that's going to be in any way involved in the sale or distribution of alcohol is going to need a license. Where it gets a little bit more tricky are businesses who might license a trademark or license its name for an alcohol product, for instance, or do a subtype of a joint, maybe a joint venture or a joint product. That's a big maybe. And that's where the analysis really becomes intense. And we'll talk a little bit about it later, but that's where I spend a lot of my time, is really following the flow of money and following the flow of ownership and control to determine whether or not that individual business who's licensing the IP will need to have a license. So when we get to, let's just assume that the answer is yes, we do need a liquor license. Before you can even apply for a liquor license, you're going to have a properly formed legal entity. To the extent that anybody still does in any way operates in a sole proprietorship, a person can have a liquor license. I've only in my practice seen two, and frankly, they were recently, as these folks were essentially looking to get rid of their businesses. They've had them for over 50 years. And so at the time, it was easy to have a sole proprietorship. Now, I certainly, as I assume most of you would never counsel a client to a sole proprietorship. So a properly formed legal entity is key. You'll have to have legal possession of a premises in any case, via by lease or by deed. You'll need to know and be able to explain in detail any of the production processes and equipment that'll be used to manufacture the alcohol. That's going to be most at the federal level, but then also at the state level. And we'll talk about the difference between that here shortly. You'll have to have all of the ownership and management details, and then source of funds. Where's the money coming from? You don't always have to provide that in detail, but you need to be prepared to, because we often get questions as to what is the flow of the money. Again, going to the ownership and management details, this is where I spend a lot of my time initially answering questions for clients and other lawyers about who needs to be on this liquor license. And that's when we say on a liquor license, what we really mean, who's going to be disclosed as an owner or a participant in a liquor license business. Again, sole proprietor, that person's involved. Any partners in the general partnership, officers, directors, members and managers of entities, all are going to be in a control position in the eyes of the federal government and the state, and will need to be disclosed. Owners, silent partners, to the extent, and I'm going to talk about this here shortly, to the extent there are any, may not need to be disclosed if they're under 10%, but it doesn't mean that they can have a conflicting interest in another liquor license business. In Colorado, and I'm focusing this on Colorado, of course, because here's where we are, but we are a dual licensing state when it comes to retail liquor licenses. This gets a little bit confusing, and I'd say this was one of the bigger hangups when I started practicing so many years ago. But for any retail license, that's bars, restaurants, beer and wine licenses, actually brew pubs and distillery pubs count as a retail license. Those will all start at the local licensing authority stage. So here in Boulder, we don't even go to the state at first. We file an application with the city, and then the city walks through its process. And that takes about 2 to 3 months. And it's a detailed process, probably too detailed for today, but that process goes on for about 3 months, determining whether or not the needs and desires of the community will be served by the issuance of a liquor license. And after it's approved, it moves on to the Colorado Liquor Enforcement Division, or the LED as we call it. And then the LED does a review. And after it's done its review and essentially checked off and just adopted what the local authority's done, it sends it back to the local authority. And then once you've met the local occupancy and inspection guidelines for each individual city, the business then is issued the license. This takes about 4 to 6 months. So if any client comes to you and says, hey, I want to open a bar on May 1st, well, it's already May, sorry, June 1st or July 1st, it's going to be a hard no. It's going to take 3 to 4 months to get that license approved. So I always tell my clients to plan out 6 months. at least before they expect to have a liquor license. There's a very limited federal component to retail sales of alcohol. The federal government simply asks that you let it know that you'll be engaging in the sale of alcohol. You fill out it's a one-page form, and you mail it into the TTB, and it gets lost in the shuffle, and nothing ever happens with it.
Mike, can I ask a question here?
Sure.
So with respect to businesses that are either taking over a prior liquor license business, for example, you have, I don't know, a cafe that also sells cocktails, and the prior business had a license. Is there a shortened or truncated time frame, or is it still a 4 to 6 month?
No, there is. And that's in the M&A section of the presentation, but briefly, I'll answer that now. No, that would be either a transfer or a change of ownership here in Colorado, and that would shorten the time period. It's still from a planning perspective, it's still very important to get out ahead of it, especially in Denver and especially in Boulder. So those are the two, I'm just going to call them problematic local authorities we have, because you have to get zoning approval before you're even allowed to submit an application for a new license or a transfer. And here in Boulder, our zoning's taking quite a bit of time, so it throws a real wrench in the process. So it still takes a while on the transfer. Change of ownership is different, and to the extent you're to do a stock or stock purchase, that timeline can be sped up, and essentially it can happen instantaneously. But I'll get there in a moment.
Hey, Mike, I have another real quick question.
Yeah.
Have you ever seen the locality approve and then the state reject an application? It seems like it's kind of a rubber stamp, but
it's not. It's a rubber stamp in my experience, it's a rubber stamp from everything that the local licensing authority is essentially meant to do, which is protect the local area, meaning needs and desires, density of we have a thing here, of course, in Boulder. Maybe you guys have read about it in the papers over the past few years. On Pearl Street, we have essentially 12, I think it's 12 right now, tavern licenses, which are bars, in a extremely small section of town. In a normal setting, that entire Pearl Street area would be well served by one, again, in theory, one tavern license, but we have 12. And of course we have 12 because that's the kind of the city center. So if that's approved by the city, the state's not going to say, no, we don't believe your needs and desires analysis and we reject it. That's not going to happen. Where it happens and where things get hung up for me are, and we're going to talk about this here shortly, are in the ownership disclosure areas. The city may say, just give us your, the LLC's managers and members, and we're good there. The state might say, well, this particular owner is also an LLC. We want to see those folks too. So that can happen at the state level. But again, I'm going to get there here shortly.
Great, thank you.
Of course. Okay, so we've talked about retail. Now it's important to talk about the supplier tier. That licensing is different in Colorado. Here, if we're going to be a manufacturer, importer, or wholesaler, so let's just say we're a brewery, not a brew pub, a brewery, we're going to apply directly to the state of Colorado. So directly to the Liquor Enforcement Division. We don't even have to tell Boulder we exist. From a licensing perspective, of course, yes, we zoning, but that's not what we're talking about today. And at the same time, we're going to tell and apply to the federal government. And we're going to get authority from the federal government to manufacture alcohol. Now, this is much different than that one pager I told you about on the previous slide with restaurants. This is much more involved. When it comes to distilleries, for instance, we're providing serial numbers of the distilling pots. We're explaining where wastewater is going to go. It's not, once you've done it, it's not extremely complicated, but it is very detailed and differs per client. So those things happen at the same time. And I generally give for suppliers a 2 to 4 month time frame from application. Federal is moving a lot faster these days, but still generally in that time frame. But I'm having most of mine approved these days within 60 days. Key considerations for entity formation, with all of that in mind, key considerations when you're helping a client, for instance, start a corporation or an LLC that's going to sell or produce alcohol. The first question I ask is, can all members or shareholders own a liquor license business? If the answer is anything other than a resounding yes, we need to dig. And again, there can be no silent investors. I hear it all the time. Well, so-and-so is just going to give me, $40,000 to start this restaurant or whatever the case may be, but they're just going to be a silent investor. No, it doesn't work that way. We can't hide anybody. So there's just no such thing as that. Everyone has to be able to be on a liquor license. I hear this all the time. Just put it in my wife's name. I'm just going to put that in my wife's name. Nothing drives me more mad because one, I don't practice law that way. We don't hide things and hide ownership interests. But that's one of the easiest ways to lose your license and then lose all your inventory and likely never getting it back. So we don't just put liquor licenses in other people's names. If the wife or the spouse, for instance, is going to own a separate business that's a separate liquor license, that is more than okay, absolutely legal. You have every right to do that, but it's not putting it in somebody's name. That person's going to have to be in control of the business. We also get a lot of questions about trusts, and the answer there is, can you just put somebody's conflicting interest into a trust? The answer is maybe. We fortunately, as lawyers, that's our favorite answer, and that's true here with trusts. It would really depend on the type of trust. The state's going to take a look at it, determine whether or not the beneficiary or the trustee has any control. If it's truly a trust where there's no control by the conflicted shareholder, for instance, then it may be okay. But that's one where we work with the state and try to explain what's going on so that we can do it. In all of these agreements, and thinking of an operating agreement for example, we generally write these so that each member reps and warranties that it has the ability to own a liquor license or to be on the liquor license, and that and again, that analysis has to happen for every shareholder or every member. If I represent the company, for instance, or if any of you are going to do this and you represent the company, I generally say, I'm going to give you an analysis for the company, but every owner or every member should seek out their own legal advice as to whether or not they are able to participate in a Colorado liquor license, for instance. And anything short of a true resounding yes, be very careful, because it can bring down the whole business. So you have to be very careful about that. And of course, circumstances change. That's why we have buy-sell agreements in these agreements, and we write them to have triggers. Essentially, if this often happens where years down the road, one of the members, let's say, was involved in a restaurant here in Boulder and said, "Hey, I'm going to go start a distillery," and kind of forgets that they're involved in the ownership group for a restaurant. Well, that's going to cause a problem. And so it may trigger the buy-sell, and that person's going to have to immediately sell back their shares or whatever the provisions provide, because they cannot participate in both of those businesses. That's happening to me more lately than I've seen, and I think it's as people start to acquire new businesses but it's come up quite a bit. Now, in my experience, clients don't know to ask those questions. So it's really important for you to dig into it because it's generally not known, and it really could bring a deal down. Same thing with new owners. If a business seeks new investment or just somebody wants to buy in, that person's going to have to qualify just as the others did early on. This is where it gets a lot of fun for me advising clients. Everybody wants to give their employees equity. Makes me pull what's left of my hair out, of course, because every employee with equity is now has to be able to participate in a liquor license business. And you could have 20 different people, servers, cooks, hostess, everybody who might get some small piece of this employee equity is going to have to disclose or affirm that they don't have an interest in some other liquor license that would conflict with that ownership. Again, going back to the 3-tier system. So in my opinion, it just becomes way too much of a nightmare. And I say a nice discretionary bonus plan is always the best there. But of course, everyone is free to do what they will. So going back to what we're talking about with the business structures, this is, I generally chart out whenever it's going to be somewhat complicated, maybe in any way, I chart it out and often just provide these charts to the state as well. Here we have a fictional wine company, the Mellon Wine Company, and it's going to have a traditional type ownership structure of 3 partners or 3 members. And then, of course, as you'll see here, going up the line to a second level, we have owners within owners. This is, I'd say, a semi-complicated structure because we have a trust there. But this is you'll see this somewhat often. All of this is workable so long as none of these folks are having any type of a conflict with a different liquor license. My expectation in Colorado is everybody involved in this chart is going to have to be disclosed to the city and the state. A little bit more complicated here, and as you'll see, we've now added a 3rd tier for one of the members of the TM holding company. This, again, fairly commonplace. In my experience, Colorado and California, for instance, will go up to the 3rd level, and you're going to have to disclose down all of these people. If they're not above 10% generally of the main melon wine company, and so some of these folks up here, Lou Smith, Turnbull, and Barbet, you would just do the math. And if they're not above 10%, they don't have to be disclosed generally, but they still can't, you're still going to affirm under penalty of perjury that nobody has an interest that conflicts with another liquor license. So even if they're not disclosed, they still have to be able to sign under penalty. I'm sorry, the entity is going to have to sign under penalty of perjury that nobody involved is precluded from participating in the license. So to take it one more step, now we have somebody in the 2nd level that owns a restaurant, a Colorado restaurant. Can they participate in the Colorado winery, even though it's so far down the chain? The answer is no. That's just a hard no. We just have to blow up the chart now or get Thornton Mellon out of the picture. So I look at these, we do quite a bit of business entity creation and counseling. I always tell, this is that prenuptial agreement type conversation when we get to the operating agreement, say, if you have anything you haven't told us about, now's the time, because it could blow up the whole thing. And I've had some extremely messy and very annoying 3-tier conversations that were just too late with clients that didn't know they had these interests. And we'd already been licensed or in the middle of the licensing process with the client, and it really creates some serious business issues. Okay, moving away from liquor licensing, the process, leases and property ownership are so critical. And I know that's a big part of most people's practice in a commercial setting. And so what are we looking for in leases in context of liquor licensing? And these are just little points that we see often, but we also have real estate lawyers that we work with, or other colleagues who don't practice liquor every day. They'll ask us to take a look. And here's what we're looking for when it comes to a liquor license business. Does a lease extend for over a year? Because with a liquor license, you have to be able to show possession of the property for 1 year plus, because that is the duration of a liquor license, 1 year. So always keep that in mind. You can't just do a quick 6-month lease, hope to get the liquor license. It's just not going to work that way. Zoning is a big issue. Make sure that the property is zoned for liquor use or manufacture. That's generally easy and generally not an issue, but nothing's ever an issue until it is. Same thing, does the landlord actually, let's say you're a subtenant, does the landlord actually allow the manufacture or sale of alcohol? I'm involved in a really nightmarish issue right now where the landlord, far removed, has said, no, you're not allowed to sell alcohol. And we've been told, my client's been told on multiple occasions that it could. So there's an issue there, and now they won't, that landlord can hold up the entire process. So very important to just make sure that everybody knows the intended use is going to be alcohol, because you may need their help through the process. Then we get into contingencies. Always be mindful of a client who is going to open a restaurant after the TI is completed, for instance. So what we generally do, to the extent we can, is look for liquor license contingency where you may not, you're going to sign a 10-year lease, but if you don't get a liquor license, you're able to exit the lease, for instance, early, and that makes a lot of landlords uncomfortable, and I certainly understand why. But the entire purpose is frustrated if you don't get a liquor license. So we look for those. Sometimes they're based on timing. Sometimes there's a kind of a cliff where there's no going back. Many landlords will require liquor counsel involved if you're going to do a contingency. You can get creative, but it's something really to pay attention to. And frankly, if I'm a landlord, I don't want to be stuck with a deadbeat client that couldn't get a liquor license anyway. So I just think it behooves both parties to look at that as a real option. Also, when you're signing leases for clients or reviewing leases here in Colorado with a lot of liquor licenses, we have distance requirements. Retail, I'm not going to get into the weeds on this one, but a retail liquor store, for instance, can't be within 1,500 feet of another retail liquor store, and that's as the crow flies. Certain licenses can't be close to any type of a school. That causes problems around the Hill. There are some exceptions. Naropa causes issues, right on Arapahoe, for instance. So these are little things that people don't think about, but you really need to be mindful before a client signs that lease that you might not have been thinking distance requirements and now you're stuck. That would play into the contingency, of course, but frankly, if you didn't know that at the outset, that's really shame on you, because that's an easy one. Percentage rent. Whenever you have a percentage rent as a part of the payment, for instance, the landlord's going to have to be disclosed on the application. And if there's a chance that if the landlord has conflicting issues, it may not be able to participate. So again, you can see where all of these tied house issues come back, and it's extremely important to work those through. Termination issues, just these are little points, but on termination, if I'm a landlord, I'm going to put in any lease that if that you have any liquor license that's there can be transferred to me, or you'll provide reasonable assistance to transfer to the new tenant. That really helps. And then inventory, what happens to inventory? Just because you obtain it perhaps through if a tenant leaves and leaves you with a bunch of inventory, doesn't make you allowed to sell it. So it's probably valueless for you, and then you just have to destroy it. So all things to keep in mind with leases. Commercial contracts, alcohol is a good, and so the UCC applies, but as I say, it's not a widget. It's highly regulated, so we can't compare alcohol to refrigerators. It's just so very different in that context. And this really comes up for us recently with collateralization and bankruptcy. Involved in a pretty messy bankruptcy back in Ohio, and there's a ton of inventory that is just sitting there with a giant question mark on it, because as we say, it can't be sold by the now bankrupt company because it doesn't have the right to sell it, but it won't give it back to us under the idea that it's a widget and it's a property of the estate. But again, it can't be property of a business or an entity that can't own it. So it becomes a very complicated legal situation. It's fun for me, but not for anybody else. So those are things to keep in mind on commercial contracts when dealing with the alcohol. I want to make a point too. Consignment almost never legal. So any contract that your client's involved with, for instance, where it's, hey, take it, and if you can't sell it, I'll buy it back. No, that's going to almost immediately be in an illegal contract term, both federally and at the state level. I'm not going to spend too much time here. There's a lot of words, but trade practices are critical to consider in any type of a commercial contract as well. Trade practices are undue influence from a supplier of alcohol, Budweiser, to any retailer. And so things that are, things you might see in contracts that would be a violation, for instance, would be pay to play. I'm going to give this liquor store $25,000 to put my product front and center and always stock it. No, that's illegal. Slotting fees, same types of things. I'll pay you to put it here. Any type of assistance, providing warehouse or financing advertising, including social media. The example I gave on that one are the Kardashians. Any particular tweet or Instagram post from a Kardashian has millions of dollars of value. If they just post your wine or your beer or cocktail, that has significant value. And so if let's take one of the Kardashians has a tequila company, if I'm not mistaken, if she was to post about a great restaurant she loves, that has she's just provided millions of dollars of value to that retail establishment, and that likely would run afoul of both federal and California law, for instance. So anything of value needs to be strictly looked at. Pretty much more of the same, but these are just little ideas to keep in mind. There's unlawful extension of credit. Colorado has laws regarding the extension of credit from a wholesaler to a retailer. Generally needs to be paid in 30 days. Of course, people take their time and generally go above that 30 days. That's illegal. But in practice, it's one thing when you say you owe, due on receipt and they just don't pay, versus saying, I'll give you 120 day. That 120 day term, for instance, would be illegal. So again, little things to keep out for there. Little items, point of sale, signs, displays, any of those types of things that might be called for in a contract. Again, keep in mind those could be an issue. And here we have entertainment, advertising, same type of thing. Labor, you might go into a big liquor store here in town on a Saturday and see different reps different liquor companies walking around, sampling and maybe dusting off some shelves. They should not be dusting off those shelves. They should not be stacking product that is not their own. But a lot of big liquor stores, I'll just say nationally as well, will definitely say, come on in, you want your wine here, you want your beer here, come on in on a Saturday and help us move beer around. And it's just free labor. And so that's also not allowed. Also, in the commercial contract sense, distribution agreements and franchise agreements. Again, very complicated issues here, but I just want to touch on them. You have different states have different franchise laws, which in a traditional sense just means that once you have sold somebody's alcoholic product, you become the exclusive seller of that product in the territory, again, as a wholesaler. And they're not allowed to fire you without cause, and they're not allowed to provide product to anybody else who might compete with you in the territory. Here in Colorado, we only do that with beer from a statutory perspective. So the only thing in Colorado that will automatically create a franchise by statute is the distribution of beer. And when those beer agreements are terminated, we have an entire statutory scheme that explains how the termination is going to go. If it's for cause, it goes down one channel. If it's not for cause, it goes down another. And there's almost always a termination fee involved. That'll be a multiple. Sometimes they can be extremely onerous, millions of dollars, for instance, for these distribution rights. But if the client didn't know about it going in and didn't try to negotiate some other terms, then they'll be stuck paying the statutory rate. Around the country, if you're doing contracts for distribution around the country, which often is the case with manufacturers, each state has their own franchise laws. Again, some are extremely onerous that you may never be able to break reasonably. And so we have these cure periods that essentially make these contracts almost unbreakable. And Ohio is one that I practice in and comes up quite a bit, where you have the right to cure. And I'll just tell you that the wholesaler will always cure, and then it resets the clock. And so you can essentially never extract your client out without some type of payment. Sometimes even with the payment, they won't let you out. So very important to keep in mind. If you're not familiar with those agreements, it's really worth spending time with learning about them. Then we get to mergers and acquisitions, which we had talked about a little bit earlier. Again, 3-tier issues. I'm not going to belabor this at this point. We've talked so much about it, but where are the financial interests? If my client owns a bunch of restaurants here in town and is going to acquire a company that has an interest in a manufacturer in Iowa, is that a problem? In Colorado, no. It's likely not. It's almost certainly not going to be a problem. There are caveats to that, but they're too deep for today. But Colorado looks to whether or not you have a conflicting interest with a Colorado liquor license. New York, California, for instance, not so kind. They look, the way their statutes are written, they look to whether you have a financial interest in any license anywhere else. New York even goes overseas, which I think is absurd, but it does. And so those are very important things. If you owned, for instance, a restaurant in Colorado and a restaurant in New York, not going to be an issue. If you own a winery in Colorado and a restaurant in New York, not an issue for the Colorado entity, but a big issue for the New York entity and or the New York owner, for instance, and they won't be allowed to participate in the Colorado location, not from Colorado's rules, but from New York. And again, this is where having each owner have their own legal representation matters, but often that's not the case. And so as a lawyer, you've got to be on top of it. This is where the due diligence matters, every state. And we can't forget the federal government either. The federal government really comes in only on those trade practices to see whether or not there's undue influence over, a manufacturer influencing a retailer, but still very important at every level to make sure you're aware of who's doing what. Another thing that comes with mergers and acquisitions or sales is the inventory. It may be that you're selling a liquor store or you're selling a building and it's got a stock of inventory just sitting there because the other operator went bankrupt. Again, you can't just take that liquor and sell it. It's just not sellable. And so you got to figure out what to do with it. There's a lot of different ways under the statutes and depending on the situation as to what you can do. But if you're going to lease a new space that used to be a liquor store and there just happens to be, boxes upon boxes of wine, for instance, it doesn't mean that you can just grab it and sell it. You're going to have to figure out what to do with it, how it got there, is any wholesaler owed for it, and what's its sellable status. So again, critical that you understand that. That doesn't come up that often, but it does come up. And then one of the big questions, and this goes to that question I had earlier about transfers versus change of ownership. If you want to do let's just say you have a client that's going to buy a restaurant and they don't want there to be any interruption and they don't have a lot of time. They want to buy that restaurant within 30 days, for instance. Nobody likes to do a deal that fast, but let's just say it happens. In this situation, almost certainly you're going to have to do a stock sale so that you're doing a change of ownership versus a transfer. Change of ownership, you don't even tell the state or the city ahead of time. It's a after sale report, and you just have to report the sale within 30 days. The new owners are going to have to go through the background check, but because the entity owning and operating the liquor license doesn't change, there is no transfer of a liquor license. There's simply a disclosure of a new ownership interest. This becomes very critical in my practice with retail liquor stores, because retail liquor stores licensed before 2016 have significant advantages to retail liquor stores licensed after 2016. And if you all remember, 2016 is when our liquor laws here changed dramatically. So whenever I get a potential sale or purchase of a liquor store, I immediately ask, it's the first question I ask, is it a pre-16 license? If it is, I walk down the road of why a stock sale is going to be the most advantageous and desired road. Now, got a lot of liabilities there. I'm sure a lot of you, as soon as I say that, kind of squeam a little bit because it's really not fun to do the share sale in that respect, but you really have to save the advantages of that license. Otherwise, on transfer, the state of Colorado, and I believe erroneously so, and I hope to be appealing this soon, will say that a transfer destroys the liquor license and creates a new one. So you won't get the advantages of that pre-16 license. So this is very unique to Colorado, but extremely important for you to catch. I've caught it I've advised clients on it after the fact, and they're very upset with their prior attorneys for not pointing it out because they would have done a share sale where they did an asset purchase and avoided all of this trouble. So that's critical when you're dealing with retail liquor stores. I've just walked through this. So now trademarks, I don't know, how many folks deal with trademarks, but I like to give a quick overview because when you're counseling, when you're in-house or out-house, in-house counsel, kind of advising on all things, it's important to keep in mind trademarks and alcohol. So right now, all alcohol is really considered to be related goods. And what that means is if your client manufactures beer or has a brew pub, for instance, and they want to apply for trademark registration at the USPTO, they're going to be compared against all other manufacturers of alcohol, not just beer, but wine, spirits, sake, anything like that, cider, and now energy drinks and restaurants. It's very annoying for us, but it's really where the USPTO is at right now. So whenever you're advising on trademarks, you really need to be thinking that not only do I need to be worried about other, identical products, but even anything in that world. The restaurants is the one that really causes great consternation and frankly, great annoyance. But fortunately, just last week, we had a nice little decision, not precedential, but a nice decision from TTAB on this exact issue. And it's Rao's Wine versus Rao's Restaurant, which also the tomato sauce that I'm sure we all have had once or twice in the past year. And that actually, I was shocked. I really thought this would have been a slam dunk given recent, the last 5 to 10 year trend. But the TTAB said no, even though the marks are identical and the goods are somewhat related, the channels of trade and the sophistication of the purchasers are strong enough that probably no likelihood of confusion. So they allowed it to go through. This is important because as as society grows and as the industries grow, finding trademarks that are registerable or even just, usable is extremely difficult. And, knocking out, we're potentially seeing a trend where you don't have to compare yourself to restaurants. The likelihood of confusion analysis is great. Now you just have to worry about all the other beverages out there. But again, just little points of interest I'm trying to raise for you. Another thing with trademarks, licensing agreements, for instance, let's go back to the 3-tier and the tied house rules I mentioned earlier. If you're going to license a trademark or have a celebrity involved or a restaurant try to do a white label product, for instance, you just need to make sure that financial interests are disclosed and that person or that business can participate. We often deal with royalties. If you think you're going to do a percentage royalty on, case sales or volume, for instance, likely not going to be permissible unless that company, the licensing company, is on the liquor license. Generally, they don't want to be, or they can't be for some reason. So you can't do a percentage. You have to do a fixed. Every state's going to be different on how they look at that fixed royalty. Generally, if it's fixed, you can do a quarterly review or an annual review and just say it's going to be $25,000 no matter what, or we're going to review it after each quarter. I'm not going to call it a loophole. I don't think it is one, but you're looking back at the performance and you're then basing the fixed royalty on prior data. Generally allowed. Control is a big one through a license agreement. Of course, if you want to keep the sanctity of your trademark, you need to have control, but you can't have control in the liquor license sense if you're not on the liquor license. So again, it's I think, lack of a better term, it's just a nightmare. So you just have to work through it. There's other concepts, contract manufacturing and alternating proprietorships, way too deep for today, but these are just ideas when dealing with the potential of licensing a trademark to an alcohol licensed company. Okay, I've given a lot of information and I'm sorry about that. But any questions or comments, I'd love to, I saved the last few minutes for this, so hopefully we have time for them.
Mike, there's a question in the chat.
I don't see it, but let me.
Yeah, Mike, I'll follow up on it. It's Judd Height. I posted it. There are, I guess, a robust secondary market for certain wines and certain whiskeys that people might want to auction or have somebody else auction for them. And I've looked into trying to figure out how that could be licensed, and I don't see it. And you noted after I posted my question that consignment is just flat out illegal. And it seems to me that taking in a bottle of collectible booze on consignment to try to auction it to other consumers probably just can't happen. Is that
okay? So sorry, this is a great question and one we deal with quite a bit. Personal sales of alcohol, generally, if I just want to sell you a bottle of Pappy for $3,800 and you actually want to buy it for that, we can just sell it. You can do that. As far as an auction's concerned, there's no auction. You're not allowed to auction here in Colorado. So you say you haven't seen it, and I've lost this argument with the LED on multiple occasions, and I've just given up. But that which is not stated in the alcohol law is prohibited. We're used to, if it's not stated, it's permissible. Here, if it's not stated, it's illegal. And here we're not allowed to auction. There's a little thing in the code about charity auctions, but it has no relevance here. So what your best bet would be is to get that alcohol out of Colorado into an auction state. I'm thinking Delaware generally is where it's going to sit. California, New York, for instance. But here in Colorado, you're just not going to be allowed to do that. Likewise, buying from an auction is going to be tricky in bringing it into the state of Colorado. Again, way too deep for today, but feel free to give me a call. I'm happy to talk about it. But here in Colorado, there's no auctioning. We don't allow gray market spirits or wine. I'd like to have that changed, frankly. And I'm working on that. But in California, for instance, if you went into a restaurant and you wanted to buy, a bottle of 1960 Burgundy, you're likely going to be able to find that at the higher end restaurants. You can't do it here almost certainly can't do it here because nobody would have that as original stock, and there's no other way to get it. So while we have great liquor laws in Colorado, generally, that's a giant hole that we need to fix.
Thank you. Appreciate it.
Of course.
Hey, question, Mike. Sorry, I'm not sure quite how to jump in here, so I'll just do it.
This is great.
With respect to the franchise agreements, the states that are on that franchise model, with respect to other distributors, the Southerns and the Republics of the world, we sort of come to be comfortable with the terms and the way that's laid out. With respect to the franchise states, do you figure out the terms by going to the state statute, and are they negotiable? Right? Or is it just sort of a take it or leave it kind of thing there?
So with like RNDC or Breakthrough, for instance, in my experience, most of those contracts are mostly take it or leave it because they're big. But I've had success negotiating the termination fees, for instance. And,
sure. Yeah.
You go through and just say what's going to be reasonable or what's going to count as net profit or, whatever the case may be. And yeah, it should be state to state. However, certain states say that you cannot modify or contract out of the statute.
Okay.
And so I always think it's good to set expectations through the contract, but to the extent your contract tries to contract out of the statutory requirements in any given state, and I'm just thinking of the states that have this in their statutes, it's just going to be struck through. You're not going to succeed on that.
Yeah, exactly. Well, and it's just kind of a funky overlay because, like, for instance, I've got a Washington distributor manufacturer that's looking to distribute in Kansas, and we're expecting to sort of see some type of an agreement come through, and they're basically just like, yeah, we're on the franchise agreement, and we're trying to get our arms around it of, what are the terms? When does the risk of loss pass? What are the termination fees? And is that just in the statute per every state? And, it maybe Kansas is non-negotiable. We're trying to figure that out, but it just seems, we were expecting a distribution agreement like the RNDCs of the world, and it just is not materializing. So
yeah, and often it's funny how many distributors and manufacturers actually don't have stock agreements.
Right.
So I'll just get a ton of different. I have a whole stock of different types of agreements. Yeah, every state's different. Certainly go to the statutes. Depending if you're looking at beer, the Brewers Association has an outdated but pretty good roadmap on different franchise states and rules, and they'll point you right to the statute, so you can just Google search that. Sure. But yeah, it's important. The other thing is, and you kind of bring this up, this is kind of getting into the weeds a little bit, but this idea of where is the sale,
right?
If they're taking it freight on board, and in Washington, what attaches? And I'd like to make the argument that the franchise doesn't attach in Washington, or let's say Kansas's franchise doesn't attach to the sale in Washington, but the seller, the manufacturer, is generally registered or licensed as a as a supplier in every state that it sells to a wholesaler. So you're likely under those laws anyway.
We've done that, but it's like, you know, like if we load on our dock in Seattle and they're distributing and transporting to some other to Kansas, and there's the product is lost somehow, who has a risk of loss? And in our contracts with other folks, we negotiate that and we feel really comfortable. And here it just seems sort of like the netherworld of and we have to sort of dig through the statute to figure out when that occurs.
Yeah, risk of loss, I think you're still really soundly within the UCC.
Okay, sure. That makes sense. Yeah, that makes sense. But yeah, so we'll keep digging with respect to these franchise states.
Yeah, feel free to call me for any reason.
Thank you, Mike.
I think we have time for maybe one more, or if not, we can wrap it up, but I see a couple people.
This is Shireen. Back to your celebrity endorsement and how that might be a maybe situation for licensing in Colorado. What is the scenario where the celebrity's interest would have to be reported to the LED? Or does that even happen?
It does happen. If the celebrity has an equity interest that would exceed 10%, for instance, or if the let's just say a financial interest. So if the celebrity is going to be endorsing one beer, a line of beers, for instance, and that royalty or that payment to that celebrity exceeds 10% of the let's just say the profit of the entire brewery. So not just that product line, but the entire brewery, it's going to exceed 10%. I would expect the LED to require a background check and full disclosure. If it's not, in our practice, what we would generally do is just send a letter to the LED saying, we're going to use this trademark, or so and so is going to have an endorsement deal. This is the financials of it. It doesn't warrant a background check, but we want to make you aware of it so that there's no issue. That's going to be on a case-by-case basis, but that's how I'd look at it.
Thank you.
Of course. Well, if that's it, then I really appreciate everybody's time. I'm always available. Please never hesitate to call or ask me any questions. As you can tell, I love to talk. So I'm happy to do so. And liquor licensing is never easy. I often wonder why I got into it, but it's fun, and there are answers generally. But you do, I go to the statutes almost daily, even though I've worked in this field for 17 years. I still have to look at statutes daily and kind of reconsider them for almost every question. So get the regulations. Make sure you always have the most up-to-date Colorado regulations, and always go back to them. But thanks everybody for your time.
Thank you, Mike. It's a great talk.
Of course. Thank you, everyone.
Thank you, everyone. This is Kyle from the BCBA. So I'll send out the CLE form, any presentation materials that I get from Mike, and a link to the recording so you can review it later if you'd like. I'll get that out by this afternoon or tomorrow morning at the latest. But thank you again for Mike for presenting, and thank you for Dylan for helping us get this set up.
Thanks all.
Thanks, everyone. Have a great day.
Thanks, Mike.